Hello, good evening, friends. Today we'll talk about the special leave petitions criminal that usually we file in the Honorable Supreme Court of India. So, what is a special leave petition? Special leave petition is like empowered with the Article 136 of Constitution of India, which gives exclusive powers to Honorable Apex Court, which are discretionary, which are not right for the litigant. They are discretionary powers of the apex court, which usually anybody who goes and challenges the orders of any of the high courts in India, they usually look at the face of the record. There has to be an error on the face of the record. That's the first point. The second point is you need to have strong question of law. It's totally on the base of question of law. If there is any error on the part of question of law, if the high court has committed any errors in the question of law related to the question of law, then it will be entertained. It's not like unlike the grounds that normally the high courts entertain. Grounds are different from question of law. Whatever grounds you have approached in the initial stage with the honorable high courts, the same will be applicable for the honorable apex court also, but they will not be interested to go in deep into the grounds. They are only interested at the face of it on the question of law part. And if your question of law and is correct, like if you have a strong basis for an appeal, then there are bright chances for your SLP will be converted into an appeal. Once it is converted into an appeal, you will get a fresh number again, and thereafter it will be heard at length. And let us assume, like if there is anything like normally the division bench adjudicates in the honorable apex court. You have around 14 to 15 courts. You have two honorable judges who adjudicate the matters in each court. If at all there is any serious question of law that arises, that will be referred to a constitution bench, which will either have 3 people or 5 honorable judges. So this is how it happens, and they usually frame an issue. Okay, and for example, like recently I have filed this SLP in the Honorable Apex Court of India under 136. So I'll appraise you a few of the points to understand what is a question of law. See, my first question of law is whether the Honorable High Court committed grave error of law in not considering the binding precedents laid down by the Honorable Apex Court in Catena of Judgments, which under Article 141, 140 and 142 and 144 are binding on courts below and subordinate courts. So my first point is there are certain judgments, Catena of Judgments laid down by the Honorable Apex Court pertaining to this subject matter, which were not taken into the consideration by the Honorable High Court. This was my first point. And the second question of law here is whether the Honorable High Court committed serious error of law in not considering the fact that FIR number so and so booked against the accused is of a grave and heinous in nature, as culpable homicide and dacoity were committed by the accused, and such investigation cannot be scuttled by staying all further proceedings in the FIR. So this was the second lacuna what we found out in the Honorable High Court's judgment, which was questioned in the Honorable Apex Court. And the third point is the Honorable High Court committed grave error in not considering the provisions of law where that is a statutory violation, where crimes of punishments above 7 years and up to death or life imprisonment are committed, comes under section 41BA clause, which allows the police officer to arrest the accused without a warrant. This was another lacuna what we found out. And the next question of law here is the Honorable High Court committed grave error in staying the arrest in gross violation of various Honorable Apex Court judgments of Satinder Kumar Antal versus CBI, it's a landmark judgment, and Joginder Kumar versus State of UP, and DK Basu versus State of West Bengal. Both of these are also landmark judgments. And then comes you have your Niharika Infrastructure versus State of Maharashtra, which says which Honorable Supreme Court of India has clearly said the Honorable High Courts should not scuttle the investigation at the investigation stage, should not stop the further proceedings, or should not stay the FIR, such kind of things, particularly when the allegations are serious or the offence is of heinous nature, which attracts punishments above 7 years or even up to 7 years also sometimes, like in cheating cases or some other whatever crimes which are registered. In such kind of cases, the Honorable Apex Court has directed the Honorable High Courts to tread with caution. Okay, and then you have another question of law which says it is a settled law that the ratio decidendi and obiter dicta of the Honorable Apex Court are also binding upon all the courts, including the high courts. This is nothing but, and whatever the orders and judgments the Honorable Apex Court passes, no matter whomsoever are the parties, irrespective, are totally binding on each and every court of India, whether it's a subordinate court or a high court or the civil authorities, every type of tribunal, and each and every person as well. Though we might not be the parties to that, but the question of law that arises in that particular judgment is also binding on in the entire country. So that is another point. So which makes the ratio decidendi, that is the reasons, and the obiter dicta. Obiter dicta is nothing but the observations of that particular judgment which are binding. All right. And so what apart from that, I have mentioned few more grounds which were the grounds of the case in the same high court. So what I mean to appraise you guys is like end of the day, what is more important in Honorable Apex Court is the question of law. There has to be an error on the face of record. That's the first thing. And the time is very precious for the Honorable Apex Court. Apex Court's success rate is very, very bleak. Hardly 1 in 1,000 or 5,000 petitions get admitted, all right, or notices are issued. Otherwise, most of them, they are straight away declined, they are dismissed. Why? Because they have an opinion that honorable high courts across the country, they do not commit any errors. That is at the first place. If at all there is any error on the face of the record, then they will be the first people, the honorable justices, to the lordships, they will be the first persons to take up the case and entertain, okay, and to grant us a relief. So there has to be an error on the part of the judgment delivered by the various the high courts, honorable high courts are. So then there are more chances of getting your petitions admitted, the SLPs admitted. All right, and hardly you can have less than, I would say honestly, half a minute if you can get in the Honorable Apex Court, then you should consider yourself very lucky, because the decision will be already made. See, normally what happens in the lower courts and the high court, in the lower courts, they listen to you, the judges, they listen to you and they adjudicate the matters. Whereas in the high court, the time is less, the time constraint is less. Per day, they have to deal with at least 100 or 200 petitions, out of which, like at the admission stage, some are for the final hearing or at whatever stages they are. So the time in the high court, I would say, honorable high courts, they listen more, they read less. In the lower courts, they listen a lot and they read less. But whereas in the Honorable Apex Court, the lordships, they read a lot. You have filed let's say 1,000-page petition. They have they will spend so much of their valuable time in reading your entire petition and coming to a conclusion. And the conclusion will be delivered in less than a half a minute. Sorry, counsel, it's dismissed. Finished. Next. This is how the Honorable Apex Court's proceedings take place. So we should be very careful in drafting. It's all about drafting and picking up the best lacunas of your judgments from the Honorable High Courts. You have to pick up at least the strongest, at least 1 to 5 points, I would say. If you have more, then it's great. And out of this, like, you can at least try to convince the Honorable Apex Court on what all question of law the Honorable High Court has committed those mistakes or errors on the face of the record. Then there are chances that your SLP can be admitted, and subsequently it can be converted into an appeal and you can succeed. This is how it happens with the SLPs. The process is same with the SLP civil or an SLP criminal. You can challenge any order of the High Court, and then you can try to get a relief in the Honorable Apex Court. But I would say it's all about question of law. It's not grounds, my dear friends. Grounds are entirely different. Grounds are more or less kind of merits of your case. But whereas the question of law is errors on the part of the Honorable High Court or the lower courts. Those errors only will decide the future course of action. Let us say if a person is convicted in the Honorable High Court, some XYZ section, okay, and the Honorable High Court has considered all the merits and handed over conviction to that guy, and if at all it has not made any mistake, then your doors for the Honorable Apex Court for the appeal and all these things are very bleak. They are almost shut. Why? Because if there is no error on face of record of the judgment, then there is no point in appeal. Even if you go for the appeal in the SLP, the Honorable Apex Court has got a stock dialogue or a face. They say, sorry counsel, we cannot interfere, no need to interfere, no need to interfere. This is the only thing what the Honorable Apex Court says, and they hardly interfere with any Honorable High Court judgments. If they have interfered, that means there is a big point, there is a big question of law that has got violated, and that has to be addressed. So this is how the Honorable Apex Court functions. This is the another point what I want to bring it to your information. And apart from that, friends, like I would like also like to bring one more thing to your notice is in Honorable Apex Court, as far as we are talking only about in this particular video about special leave petitions. So if at all there are appeals, normally the Honorable Apex Court would entertain. There are more chances of getting it considered by the Honorable Apex Court. That is anyhow there. But whereas for the cases of for bails or for the cases of quashing, against quashing or for quashing, such kind of SLPs, the chances are very less, very bleak, unless and until you have a strong point. And one more thing, yes, now I got it. The one more thing is, if at all, I've already told you, if at all that there is any strong point which two-judge bench cannot decide, that will be referred to a larger bench, a constitutional bench of either 3 judges or 5 judges, or if at all the judgment is of 5 judges, then it will go to 7 judges, already even more than that, or 11 or 13. But nowadays, it's hardly the Honorable Apex Court is constituting up to 5 judges normally. So if at all there is anything of the larger interest, then it will be referred to the larger benches. So I would say the Honorable Apex Court is more like a policy making body. Let us take this criminal major acts. If you see various sections of the IPC, let us start with for example 420. 420 is a cheating thing which you have a definition and the ingredients required to make out a strong case of cheating. You require dishonest inducement and delivery of property is mandatory, and finally which comes where you have to show a wrongful gain or a wrongful loss to the complainant. So these are the 3 ingredients which will make out a case and to bring home the charge of the 420. But whereas this is very simple, there are millions of cases that are getting filed every day across India for 420, right from the Malias to Nirav Modi's. Plenty of big shots are there who got this guy who are facing charges under 420. And whether really that 420 attracts or not, it all depends on the judgments of the Honorable Apex Court. Honorable Apex Court has delivered catena of judgments which will decide whether how the lower court below, the trial court has to approach, how the high court has to approach, how they have to deal with that particular thing. It's all about the question of law. The policy will be made by the Honorable Apex Court, which will be followed by the courts below. If they don't follow, then you have a point. Whether the section is of 420 or XYZ section 302 or anything, 498 or even any XYZ sections, it all depends on whether the courts below and the high courts, they have followed the binding precedents or not. The binding precedents in the sense that already the judgments delivered by the Honorable apex court on those particular sections, because those particular sections, the judgments delivered are all about the interpretation. In this particular book you cannot find any interpretation. Law is all about interpretation. There is no straight jacket formula for law. It all depends on interpretation. How you interpret, how I interpret as an advocate differs from my learned friend. So how they interpret differs from someone else. So all these interpretations, finally the lordships have to consider, and they have to agree with your point of view. Then only you will have a point, then only you will get a relief. Otherwise, if they don't consider your points, then again the chances of dismissal are very high. So it's all about how you make up your case and how you tell. There are, see, in other case also, like I have seen the constitution bench, I think like it's a demonetization case. Both side councils have said like they have all huge suitcases of documents running into lakhs of pages. The honorable CJI, he has directed both the councils to bring out only 10 points each. You can imagine that was a case which was running in the honorable apex court for few years, maybe 3 or 4 years or 5 years, whatever. But finally, more than that, in fact, finally they hardly have time for even to listen to the 5 or 10 points. So you can imagine it's all about bringing the best ground and best point, the best question of law to the lordship's notice. If you bring the best question of law to the lordship's notice, and if there is an error on the face of the record, then it's thumbs up for you. You have won the case. I am assuring you this is how it works with the honorable apex court. And friends, I don't charge anything for any legal advice. Because law is a passion for me. It's not this profession, it's like a passion for me. And unlike my learned friends, I don't charge anything for giving advice. If I like, I can give you advice, and on any particular case you can approach me. And the second thing what I'd like to bring to your kind notice is, in the honorable apex court we are specializing in the special leave petitions. Apart from that, we also deal with the contempt petitions. Contempt petitions are two ways. One, you're a party to the already an order which was violated. That is the first thing of the apex court. The second thing is, even if you're not a party, by virtue of section 141, 142 and 144, and by virtue of section 129, which empowers the honorable apex court, has got it's a court of record and it has got original jurisdiction. Even if you are not a party to that particular judgment, and that judgment is applicable to your case and you're getting affected by it, you can always approach the honorable apex court or even high courts with a leave petition. You just have to implead into that particular thing. You can beg the court to grant a leave to you. This is how it works. So, my dear friends, we are at Sridhar Dayal law firms. We are located in New Delhi, Karol Bagh, and also in Hyderabad. We deal with the high courts across the country, and particularly with the honorable apex court. In honorable apex court, you have very few provisions, whereas in high courts you can file hundreds of different types of petitions. But when it comes to the honorable Supreme Court, there are very less type of petitions, and they won't be entertained for such a long time. They don't delay them. Straight away, they either they dismiss it. If they admit it, they'll finalize it soon. So you might get relief in a shorter span of time, whatever relief you are praying. So my dear friends, once again, thank you so much so it's been a very lengthy video. I hope I will try to cut short into the smaller ones in future. In case if you have any kind of legal assistance required, or you want to approach the honorable apex court directly under article 32 by way of a writ petition or habeas corpus, writ of certiorari, or even if you want a quo warranto, writ of prohibition, these are all various types of writs the Constitution of India has granted us. We should be very thankful for the Constitution of India. Alright, and the second thing, for an SLP, the only issue is with the SLP is it's at the discretion, it's not a right. And last but not the least, contempt petitions. Contempt is a very challenging thing, and I'm a keen observer. I am basically from a research background, so my research is very strong. So I am more into the honorable apex court of India judgments. So whatever judgments the honorable apex court of India has delivered which relates to your particular case, we can always, if there is any violation, then we can always approach either the high courts or the honorable apex courts by way of a contempt case or a contempt petition. In high courts it's contempt case, whereas in honorable apex court it is called contempt petition. All right, and I thank you so much. And last, I would like to tell you what our motto at Sridhar Dayal Law Firms is. See, we don't sleep, nor we will let you sleep until we get you justice. That's it. Thank you.